Uh, the other issue that was indicated by the North Gauteng High Court was that the delay in putting in place the necessary mechanisms, structures, resources, uh, and resources to ensure that foster care system operates in a sustainable and effective manner is unconstitutional, unlawful, and invalid, because it appeared that there were no systems in place and no mechanisms in place that existed at the time in order to ensure that there is no foster care backlog, and that the declarations of invalidity in paragraph 2, which is paragraph 2 of the order, are suspended for 24 months from the date of this order, which is 24 months from 2017, whereupon, in terms of the ensuing provision, was that the Minister of Social Development had to prepare and introduce before Parliament the necessary amendments to the Children's Act and the Social Assistance Act to produce a comprehensive legal solution. I must indicate to you, Honorable Chair and Honorable Members, that the Social Assistance Amendment Bill was tabled before Parliament and processed and finalized in 2020 December. It is already in force. SASSA is already implementing it. And the benefit for it is that orphans are already benefiting from that, who are also part of what we are going to discuss about in terms of this particular bill. And the Children's Amendment Bill is the one that we are busy with now as one of the pieces of legislation the minister was ordered to amend in order to come up with a comprehensive legal solution. It must be indicated, Honorable Chair, that when the North Gauteng High Court presented that we need to come up with a comprehensive legal solution in terms of amending the pieces of legislation for the department to address that, the Children's Amendment Bill was already in place, but it was an all-inclusive amendment bill catering for all other issues relating to child protection. It had about 146 clauses, and out of those 146 clauses, the first batch of those clauses to be removed related to early childhood development, because ECD was removed from social development to basic education, and there were clauses that related to ECD in the bill. Subsequent to that, there was also an issue of foster care. So, because the foster care issue is time bound and the order expires in November, as coming November, the portfolio committee took a decision that let the bill be split further and remove the clauses that relate to foster care and have a separate bill from those, and the rest of the clauses will be dealt with as a committee bill at a later stage. But for the purposes of meeting the deadline, let's deal with this. So the department identified 12 clauses from the bigger bill. It must be indicated, Honorable Chair and Honorable Members, that it is accepted that yes, these clauses are not it's not only these clauses that may have an impact on foster care, but these clauses were chosen in terms of their closeness to the issue, because there are other clauses like adoption in the Act and other clauses that would have been dealt with, say, corporal punishment, which we would argue that they also form part, or they may form part of foster care at the end of the day. But we only chose the clauses that were closely linked to foster care. So 12 clauses were identified, that is with the exclusion of the definitions, and then there were two more clauses that came in as a matter of consequence as we were busy developing this foster care bill. and also the short title, because you will see in front of you that you've got 16 clauses instead of 12 clauses as I present here. I'm just indicating the history to these. So the department identified these 12 clauses from the all-inclusive bill, which directly contribute to the comprehensive legal solution as ordered by the North Gauteng High Court. These clauses provide for a legal framework that directly addresses the identified foster care challenges resulting to the High Court's directives. They seek to strengthen the provisions of the Children's Act that are aimed at providing a good quality child protection system, of which foster care is a component thereof. It must also be indicated, Honorable Chair, as a matter of background, that these clauses that we identified revolve around the definitions. That's a few definitions from the bigger comprehensive bill, and also provisions that put structures and mechanisms in place, and also clauses that provide for diversified.
Yvonne, can you switch off your mic?
Okay, thanks, Chair. So these clauses provide for diversified access to legal mechanisms for the care of children, and also provide for the determination of children who are at risk and also in need of care and protection. They also provide for the court processes for the making of decisions if children are in need of care and protection. And one such clause that has been provision that has made it to the list of 12, making this that is forming this bill, is one that deals with guardianship, which is section 24, and as a consequence, section 45 was also amended, because the idea was that if the guardianship is extended to children's court, it may be easy for people to access children's court in order to secure guardianship, as opposed to high court, which is more expensive. In that way, making a number of children to be in need of care and protection, because people don't have money to approach the High Court to deal with that. There is also an issue around the management of foster care orders, the extension of foster care orders, and provision of foster care placements, which are provided for in this proposed bill. Again, Honorable Chair and Honorable Members, there is an issue of clarification of the caregivers within a cluster foster care provision, which will also contribute towards the comprehensive legal solution, thus minimizing the confusion regarding the responsibilities of these caregivers, and making a distinction from the foster parents who are not in the cluster foster care scheme. And again, also streamlining the foster care provisions, thus diversifying the foster care interventions. You will note, Honorable Chair, in the bill that was shared with you, the issue of the definitions that have been taken into account around the cluster foster care scheme, which seeks to diversify the foster care interventions and thus contributing to the foster care legal solution as ordered by the court. The other definition that has also made it into this particular bill is the definition of an orphan. You will recall, in terms of the existing legislation, that is the Principal Act, the Children's Act, the definition of an orphan is that of a traditional definition where both parents are deceased. But what this bill is introducing is an orphan whose parent is deceased, even if it's just one parent. This is a recognition of the fact that other children are children of single parents, where the other parent is unknown or the whereabouts are unknown. So we are saying those children should not be disadvantaged by virtue of only having one parent in their lives. So the definition in terms of this bill is saying that even if it's just a maternal a child is a maternal orphan or a paternal orphan, is okay, as long as just one of the parents is deceased, they will be qualifying for the benefits of orphans in terms of this legislation. The Social Assistance Amendment Act that has already been finalized in dealing with this comprehensive legal solution is already taking cognizance of that, and those children are being offered the benefits as the child support top-up grant when they present themselves at SASSA as from June, when the regulations were finalized for the Social Assistance Amendment Act. So it's already operational. This bill also provides for various forms of care for children, Honorable Chair and Honorable Members. It addresses the mechanisms that are required by caregivers to care for children that are orphaned or abandoned that may not necessarily require a foster care placement, purely because they may require a legal mechanism to enable them to make decisions for children in their care. So they also provide for a legal mechanism that contributes to the comprehensive legal solution to foster care. And furthermore, this makes the legislative provision more accessible in terms of serving the best interests of the child, which is of paramount importance at all times when dealing with children in terms of Section 7 of the Children's Act. This bill also seeks to put a control mechanism to ensure that the required standard for provision of child protection services is achieved, in that way contributing to the comprehensive legal solution. Because at the back of our minds, we must always remember that what we are trying to address here is a comprehensive legal solution as ordered by the North Gauteng High Court. So all these provisions are geared to answer that particular concern from the court. So these provisions also contribute to a legislative response to a challenge required to the required structure for the desired child protection system. It is also a required mechanism for responding to the demand for quality child protection services that include foster care services. So it is actually a response to all those issues that at the end of the day, when viewed collectively, will at the end of the day address the issue of comprehensive legal solution that the North Gauteng High Court order directed the Minister of Social Development to come up with. It also, that is this bill, seeks to address, it also seeks to address the systemic challenges by providing adequate resources. Because one that of is the this bill that was identified, or some of the issues that were identified, revolved around the sufficiency of social workers to deal with the demand for child protection services that include foster care services. You will recall, Honorable Chair and Honorable Members, that when this piece of legislation was finalized sometime before 2005 and ultimately signed off in 2005. One of the critical issues that was what was raised was that this bill, that is in fact the act, the entire Children's Act, would require close to 70,000 social workers to fully implement the provisions thereof. But the challenge is that we've always been having less than that number, that is the entire population of social workers, as per the South African Social Service Professions Council. So we always have that challenge. That is, the more the services for social workers are required, the more the challenges come up, because there is a less number of social workers that we have in the country versus the demand, being this particular legislation being one of those that demand more social workers. So the required, also the required tools of trade to enable social workers to perform their duties. These are the challenges that we are facing. Even when we visited KZN at the time during public hearings with Parliament, it was clear that the issue of tools of trade is a challenge. One of those, that's the availability of vehicles to visit these homes, because these children who are in foster care need to be supervised and visited from time to time, but there are no cars as one of those examples. So that also needs to be taken into account over and above other issues in order to comply with the legislative prescripts, and also the issue of absence of offices for social workers throughout the country. Some we have challenges. There are temporary structures in caravans because of the challenges that we have. So the court had ordered not just to come up with a comprehensive legal solution in as far as the amendment of legislation is concerned, but also with systems, structures, and processes that must be in place in order to have a comprehensive package in dealing with this issue. So in order at the end of the day to put in place the required child protection mechanism and structure to maximize compliance to the entire Children's Act, which has not been adequately resourced for implementation purposes. Again, Honorable Chair, the establishment of the child protection units are also dealt with in this particular bill, which seeks to strengthen the comprehensive social work assessments and the provision of responsive prevention and early intervention services, thus minimizing the need for children being placed in foster care. Because what we are saying, Honorable Chair and Honorable Members, is that the lesser the children in the foster care system, the better for the department in terms of achieving what is required. So all these are geared towards ensuring that at the end of the day, we get a comprehensive legal solution to foster care. And again, Honorable Chair, some of the clauses in the bill seek to limit the placement of orphaned and abandoned children, as I've just indicated, in the foster care of families. You will understand that what this bill has also introduced is that those children who are living with their families, that is, those orphans who are living with their families or relatives, should be shifted from the foster care system and be diverted towards the top-up grant, as in terms of the Social Assistance Amendment Act that has already come into place, because most of the time those children are not necessarily in need of care and protection because they are within their families, with their families and relatives. So the lesser the children we have in the system, the better for the system, so that it is not overburdened at the end of the day. So such placements are partly resulting from non-comprehensive social work assessments as prescribed in Regulation 55.1. And then at the end of the day, these are not comprehensive enough due to the high caseloads as well as the generic social work model that is a prevalent practice in the country. So this bill seeks to address that shortcoming so that at the end of the day, we do not have challenges around huge numbers in the system. Also taking into account that we are not just reducing numbers for the sake of reducing numbers, but also in terms of properly implementing the legislation as indicated in its wording. These clauses in the bill also contribute to a comprehensive legal solution by addressing a symptom rather than just dealing with the reactive kind of a situation. That is the lack of comprehensive social work assessments, which has been identified as a challenge through the establishment of, that is, focusing on the establishment of the child protection units by putting a specialized child protection model as a system mechanism for provision of child protection services. So such an undertaking will strengthen the social workers' responsibilities relating to the children's court processes to determine whether a child is in need of care and protection. Again, Honorable Chair and Honorable Members, the clauses in this bill are also mindful of the fact that there is a need to limit placement of children in need of care and protection, although we must not be seen to be infringing on the constitutional right of this category of children at the expense of non-responsive social welfares and child protection system arrangements. So we do take it into account that although some of these children are with their families, that is the orphan children, are with their relatives and families, we are mindful of the fact that they do have the constitutional right to our benefits as a department, and by removing them and placing them with families and categorizing them as such, we are not undermining the existence of their constitutional rights. So the modifications to these clauses in the bill that are being submitted to put additional mechanisms to ensure that such children who may be at risk, even in the care of family members, are not automatically excluded by virtue of their relationship with the caregiver, as I indicated, but just to indicate that they need to be removed from the foster care system, but also benefiting from the other rights that they are entitled to in terms of this legislation. Uh, Again, Honorable Chair and Honorable Members, it must be noted that this bill seeks to complement the amendment to the Social Assistance Amendment Act of 2020 and its regulations. As I indicated earlier, that when the minister was ordered to come up with a comprehensive legal solution, she was also directed to amend the existing pieces of legislation. So this is not the only piece of legislation. The Social Assistance Act was also amended, and that amendment was finalized in 2020, and it must be read together with this. And that Social Assistance Amendment Act is providing for the extended child support grant as part of the comprehensive legal solution, meaning that a large number of children will be shifted from the foster care system and be diverted to the child support top-up grant, which is already being offered. And I must indicate, Honorable Chair and Honorable Members, that there are so many children since June who have already started benefiting from that system, and which children would have been part of the foster care system if that legislation was not amended. And again, it must be understood that the children who are already in the foster care system will not be affected by this. It only relates to children who are new in the system, who are just entering the system, taking into account that those who are already benefiting from the foster care system are not being affected by the introduction of this piece of legislation, as it does not operate retrospectively. That is the legislation that has already been finalized. So again, Honorable Chair, these clauses seek to contribute to the decision-making process as part of the comprehensive legal solution. That is the indication, for example, in Section 155 of the Principal Act, being the Children's Act, which requires a social worker to investigate whether a child is in need of care and protection. And part of that investigation requires a comprehensive social work assessment. So this is taken care of in this amendment, so that that decision-making process is not cumbersome, and at the same time it does not take too long at the expense of the child, so that at the end of the day the child can benefit without having been inconvenienced by that. So this decision making is usually the case when courts have to make a decision in terms of whether a child is in need of care and protection, with the assistance of the social worker who has made a comprehensive social work assessment. So this bill is addressing such issues, so that at the end of the day, these challenges are dealt with. Again, Honorable Chair and Honorable Members, this bill also provides for the clarification of the role of caregivers within a cluster foster care scheme, as indicated earlier in terms of the definitions of a cluster foster care scheme that has been amended, and thus contributes towards the comprehensive legal solution, because it seeks to minimize the confusion regarding the responsibilities of the caregivers, and in that way it simplifies the cluster for foster care mechanisms. Is part of the comprehensive legal solution that has been identified, and the clarification that is indicated also promotes compliance with the provision and diversification of the scope of foster care services that are supported by the comprehensive cluster foster care regulations, and compliance with these regulations will be supported by clauses of these amendments, so they will be read as a single whole that at the end of the day need to be taken into account. Again, Honorable Chair and Honorable Members, still on the substantive provisions of this, it will be it is indicated that this amendment provides for the provision to address the mechanisms that are required excuse me, by caregivers to care for children that are orphaned or abandoned, who may not necessarily require foster care placements, as indicated earlier, that some of these children do not necessarily need to be placed under foster care by virtue of being orphaned. But because they are with their family, I mean, they are residing with their families, it becomes easy for them to be taken care of. And again, the first option would be that if they are not with their families, that of adoption, as opposed to the foster care system. Hence, I indicated earlier on that adoption may also be part of this, but it may not be directly linked at this stage, but by way of extension, it is also part of the system. So it is a preferred choice as opposed to foster care. Again, Honorable Chair and honorable members, the amendments that we are presenting before your good selves today also provide for another dimension to address the mechanisms that are required by caregivers to care for children who are orphaned or abandoned, as I have indicated, that they should not necessarily fall under the foster care system, but also other placements, as previously I alluded to. So they thus provide for a legal mechanism that contributes to the comprehensive legal solution for foster care by reducing the demand for unnecessary foster care placements, and thus serving the best interests of the child, which is a key principle that we always keep at the back of our minds from time to time. as contemplated in Section 7 of the Children's Act. Again, it must be noted, Honorable Chair and Honorable Members, that one of the major contributory factors to the foster care challenges is a systemic issue which results to social workers' non-compliance to the legislative prescripts to extend the foster care orders on time. So these clauses seek to address that because at the end of the day, this results to the alternative care, that is the foster care, in terms of the children's constitutional rights being compromised due to lack of enabling systemic arrangements for the social welfare and child protection systems. So these clauses seek to cure that defect that has been identified during the processing thereof, and also to take into account that the unbundling of these systemic challenges will enable the presiding officers to extend the alternative care, that is the foster care orders, in a manner that is in line with Section 48 of the Principal Act, because Section 48 of the Principal Act is already empowering the presiding officers to extend these orders. And this Section 48 has to be read with Section 65, which speaks about monitoring and quality assurance, and also the terms of in terms of the time frames as contemplated in Section 159 of the Children's Act. Again, this will contribute to the comprehensive legal solution if these are put in place, because we will in that way be putting a mechanism that prevents these orders from lapsing, which is a challenge that we have from time to time, because once a foster care order lapses, then it exposes the child to vulnerability, and there is confusion that might ensue from there. Again, Honorable Chair and Honorable Members, part of the challenges that are experienced with foster care relate to the periodic 2-year extensions of foster care orders due to the presiding officer's reluctance to issue Section 186 orders. So these extensions are cyclical in nature as we understand them, and they occur until the child is 18, being renewed on the periods of 2 years, has been indicated, which in turn increase the administrative processes for social workers, because every second year it means the order has to be renewed, and so much work has to be done by social workers in order to ensure that this gets to be extended or this gets to be stopped, depending on the circumstances of the child. So that further carries a risk of these foster care orders lapsing due to these systemic challenges, and that results from the reluctance that arises from the lack of supervision of foster care placements of children in foster care by social workers. So proper implementation of these clauses will therefore provide for a lasting solution to this challenge. Again, Honorable Chair, with regard to these clauses, it must be understood that there is, if there is strengthening of Section 186 provisions, that will create a conducive mechanism for presiding officers to begin to issue more Section 186 orders, resulting to less foster care orders requiring periodic extension of foster care orders. And this bill seeks to address that shortcoming so that at the end of the day, we do not have children who are not being attended to due to the systemic issues that we have as challenges. It must be noted, Honorable Chair and Honorable Members, again that the strengthening of the provisions of Section 186 that seeks to make a provision for MECs to establish well-resourced child protection units and quality assurance units will contribute towards the comprehensive legal solution. It will do so through a legislative requirement to address systemic challenges by providing adequate resources. which resources, as I indicated, are from time to time a challenge in the department. And such resources relate to the social workers who must be available to deal with the demand for child protection services that include foster care services, and also the required tools of trade to enable social workers to perform their duties, and also complying with the legislative prescripts, as well as the offices that are required, because social workers sometimes they've got challenges, they don't have offices, and all these have to be dealt with in order to address the shortcoming that we have, so that at the end of the day, we will be seen to have put in place the required child protection mechanisms and structures, thus responding to the comprehensive legal solution in as far as the systems and structures and mechanisms that must be put in place as ordered by the North Gauteng High Court. Again, Honorable Chair, it must be understood that the establishment of the said child protection units will strengthen the provision of prevention and early intervention services, thus minimizing the need for children being placed in foster care. And in that way, the number of placements will drop and the burden of the foster care system will be reduced, and that will assist so that moving forward we do not have hundreds of thousands of children facing the risk of their orders lapsing and putting them into some challenge out there because of not being able to access their benefits due to a backlog that we need to address, and which these provisions seek to address. So these provisions need to be viewed from two different angles: to deal with the backlog and at the same time to also ensure that there is no future clogging of the system. Hence, some of them are moved to the top-up grant system, and also to other alternative placements like adoption, as indicated. With that in mind, Honorable Chair and honorable members, we must also take into account that the road is not smooth when it comes to the development of this particular bill. There are contentious issues that we need to be mindful of, which you may be confronted with, more especially during the public hearings. And one of those with regard to this particular or these particular clauses has been that the department or the portfolio committee should have included in that 12 clause list I was relating to in the beginning. The department should have included section 21, which is clause 10 of the bill. So it's one of the contentious issues. And we are saying, Honorable Chair and honorable members, this is what we need to take into account, that the organizations or the stakeholders who insist on clause 21 being part of these clauses, is that there is a challenge with that clause being included in these clauses, in the sense that the rationale for these clauses, in fact, it's a brainchild of the department, if I may put it that way. The department had indicated that no one may be discriminated based on unfairly discriminated based on marital status, and it picked up an issue that unmarried fathers always get a challenge with regard to issues of parental rights and responsibilities, in the sense that they are viewed as being unmarried. They don't have the same benefits as the married fathers. So we're saying, let us equate this with clause 9 of the Constitution, and they must not be unfairly discriminated. But when we moved around the country, and as the portfolio committee also did that, it appeared that the meaning of clause 10, that is the amendment to section 21, gets to be blown out of proportion. And it then doesn't serve what it is meant to serve. Hence, we said, let's put a hold on it for now and not make it part of these provisions so that we have a thorough look at it. As I indicated, that it provides for the rights of unmarried fathers. One, the argument would be that what about the rights of unmarried mothers? It's not about that. It's not a comparison between unmarried fathers and unmarried mothers, because we are saying unmarried mothers are already the custodian of their children. So that is not what we are resolving with the amendment of Section 21. We are simply resolving the unfair discrimination on marital status, those who are married and those who are not married as fathers. And now the challenges that we face as we are sifting the comments from various stakeholders is that they want to extend the meaning of this amendment to such an extent that it includes the issues of custody of children. They talk about automatic custody. Fathers must have automatic custody of their children, and we are saying no. We can't have automatic custody. Unmarried fathers can't have automatic custody because that has to be determined by the courts during the cases of divorce or during any such similar cases. It cannot be correct that the Children's Act talks about automatic custody. The courts will have a role to play in determining that fact at that particular point in time. We can't have a blanket approach for every unmarried father, because the characters of unmarried fathers differ from each other, in the sense that some of the unmarried fathers, same as the married fathers, are not fit and proper, and therefore in that way that has to be determined. And also, when we are legislating, we are mindful of the fact that we cannot be seen to be usurping the powers of the courts. The courts already have that power to deal with that. Hence, this particular clause is not part of the clauses that we are discussing today. It has not been included, but it is a contentious issue that must be brought to your attention, Honorable Chair and Honorable Members. And the other issue is about the payment of damages, because as we moved around, the traditional leadership is adamant that no unmarried father can have, which we agree with from the customary point of view, no unmarried father can have automatic rights and responsibilities without addressing the issue of damages. That has to be taken into account. So that needs to be addressed and be crafted properly so that at the end of the day, we know what we are dealing with. And that alone has necessitated, the further consultation with the House of Traditional Leaders. And we said, if we're going to consult with the houses of traditional leaders in the provinces, this may delay the processing of this particular bill, because we've got a deadline to meet at the end of this particular year, that is at the end of November. So if now we are going to deal with that, it will delay. And again, if we are saying we need to approach the houses of traditional leaders in all the provinces, this bill needs to be reclassified, because according to the classification we received earlier, was that it is not a bill that affects traditional leaders, and therefore could not be referred to the House of Traditional Leaders as per the parliamentary rules require for such bills. So if we were to entertain these from the traditional leadership point of view, would need to approach that house, and that may also be time consuming for us. And we do not want, at the end of the day, the respondents in the North Gauteng High Court to be caught wanting at the end of the day and be in contempt of the court for having failed to finalize this legislation before the deadline that has been set by the court. And issues of visitation rights, in the same way as in custody that we related to earlier, which the stakeholders say they must be automatic and must not be time bound and all that. We are saying all these issues need further engagement with the Department of Justice, because these are matters that are dealt with by the Department of Justice, because this area is highly intersectoral in nature and cannot be determined in isolation from other departments, as Department of Social Development is not the sole custodian when it comes to these matters. And also the issues of maternal versus paternal favoritism. There is a long list of issues that have been mentioned around this issue, some of them which are not legislatable in nature. But I'm just presenting this to you, Honorable Chair and Honorable Members, so that you get an understanding of what you may come across when you are going around for public hearings around the fact that Clause 10 was not made to be part of the clauses that seek to achieve the comprehensive legal solution. So these were our reasons to say it's not that we are saying all what the stakeholders are saying to us, but we are saying every clause is important, but unfortunately the timing is a factor. We'll still be able to look at this clause when the Parliament processes the committee bill that is before it, because out of those 146 clauses I referred to in the beginning, some of these clauses have been taken out as these clauses, and some of them went to ECD as the ECD migrated to DBE, and the rest will be dealt with, including this one, as a committee bill, and this will still be entertained at that stage, and people will still have an opportunity to engage parliamentarians in dealing with this particular important matter. We are not ignoring it, as has been indicated during public hearings, that we are ignoring this. We are not ignoring it, but we are saying it needs some deeper thinking and greater attention in order to be dealt with. On that note, Honorable Chair and Honorable Members, the department would recommend that the honorable members of the legislature take note of the presentation or that is of this bill as was introduced in Parliament and its current status as of today. Thank you very much, Honorable Chair and honorable members.
Thank you so much, for the briefing. I will hand over to members to ask questions of clarity. However, before I do that, I have questions, Leander, to you. It is for the first time to have a presentation like this when we talk about the bill. This presentation that you have given, yes, it is holistical and we understand it, but we need to understand exactly, because I understand that there are how many clauses are being amended, because I according to what you sent to us, I know that there are about 15 clauses that are amended, and according to the presentation, it is more like a story. You have not broken it clause by clause, so that we know that which clauses are amended and what is the issue in each clause. So it is important for you to send us before we go to the public hearings the clauses that are amended, so that it can be clear to us. That is number one. The second one is what was the issue for the matter to end up in court in the first place? The matter of the Center for Child Law versus Minister of DSD, North Gauteng judgment. Can we get a summary of the facts of the case? It will also assist us. I thank you. Honorable members. Are there any questions of clarity, honorable members?
Chairperson,
Honorable members, am I audible?
you are audible.
Is that Honorable Majola?
Correct, Chairperson.
Okay, Honorable Majola.
Thank you, Chairperson. Mine will be checking from Mr. Mchochisa on looking to all these amendments. Is it possible for them as the department to also write down the advantages that this amendment will be coming up with? Because when we are going to people, we must be in a position of explaining what was bad, how it has impact, how it has been impacting on them before this court. I think that will be going back. What was the reason for that court order that we are following? Yes, and the other thing is, I would say, as much as he has not been coming up clause by clause, because it's something that you have requested here to do before we go to the public. The issue of being a single parent and those who are married, who are couples, whatever you can call, I would say on that note, I commend what is being addressed by this bill. But all that, if the department can lay them down, put it in a layman's language so that it talks directly to them without being a big English, because most of the people that are highly affected by this, we are talking of the grannies that are taking care of these kids. That is number one. The second one, it will be the issue of the tools of trade. Tools of trade that are part of the bill when it is being implemented. I am saying that you talk of the equipment, the material capacity, as well as the capacity of the human resource. I'm looking at a situation when the department is now struggling to pay warm bodies without talking of employment. We are struggling to employ new social workers. Now I'm checking whether national has been in a position of checking the capacity bureau of these provinces in making sure that this act is not just in paper, it is implemented with the provision of both human resource capacity as well as the equipment. Have they done that? Thank you.
Thank you, Honorable Majola. Is there anyone else with a question of Gary?
Chair, this is Les Govender.
Governor?
Yeah, firstly, thank you very much to the presenter for the presentation. I think, the presenter has laid the cards on the table in terms of presenting what is before us, as well as the challenges. And I think Honorable Majola has placed their finger on the challenges. Chair, you asked a question of why did this matter appear before the courts? Now, when we pass legislation that we are not able to implement effectively, then someone will take us to court. Now, these amendments that are before us, we can see that there'll be a number of areas where social workers and the departments in the various provinces are going to find very difficult to implement. And that is because, as Honorable Majola says, we don't have sufficient social workers. We don't have sufficient tools of trade. And therefore, it's going to be very difficult for social workers to, for example, go and visit those children that are in foster care as required in these amendments, and produce reports at least once a year, so that the extensions can then be implemented. Now, if we do not have these tools of trade, if we do not have sufficient human resources, by way of social workers, then how are we going to implement these regulations? Because then we will find that we will be taken to court. Now, there are various clauses that I would like to ask questions on, but I will leave that for after the presentation is done clause by clause. But also we have the challenge of the NPOs. Now, the NPOs have social workers who are paid less than those social workers that are employed by government institutions. And the challenge there is going to be that those social workers in those NPOs are not going to be able to comply with these legislations. And again, we will be taken to court. So these are some of the things that we need to grapple with, Chair, before we say yes or no to these new regulations that are coming in. Because I can see that these regulations will be very effective in taking care of the needs of foster care children. But we need to be careful that we do not pass legislation that we know will not be implementable. Thank you, Chair.
That's correct. Yes.
Thank you, Honorable members. Is there anyone else?
Honorable Chair, I've got my hand up. Daphne?
Okay. That is our legal advisor, Ms. Kuzoyo, Daphne Kuzoyo.
Thank you, Honorable Chair. Honorable Chair, may I request Mr. Mchuchisi to take us through, to clarify, I think it's the second last slide, where he talks about the contentious clauses that we might encounter when we do our public hearings. There might be questions that may arise. If you could just go down, sir, to your second last slide. I saw that you were talking about it impacting on clause number 10. And when I look at clause number 10, this clause seeks to amend section 159 by providing that a court may extend an alternative care order that has lapsed or that makes it an interim order. So I'm not sure how do those issues that you have itemized in that slide talk to Section 159 and Clause 10 as it amends Section 159. If you could please clarify that for me. Thank you. Thanks, Chair.
Thank you so much. I think Mr. Luanda, Patricia, you have get our questions. Can you answer the questions? And also, Luanda, can you also tell us why there was such a delay with this bill? Why were you sitting with the bill for so long?
Okay, thank you, Honorable Chair and honorable members, and thanks for the questions. I will just attend to those that I can manage to answer and hand over to my colleagues present here to respond to some. Let me start with the one you have just asked the Chair, why the delay? If I may get clarity, delay from 2011 or delay from 2017, because the North Gauteng High Court order is saying the delay by the department in putting systems and processes in place, which is a historical matter. One of those issues that is being referred to is this very same capacity that we are dealing with. I indicated that when this bill was passed by parliamentarians in 2005, in fact, before that, a study was conducted by one company, Cornerstone, and which included the implementation plan. And in terms of that, the indication was that in order for the Children's Act to be fully implemented in the country, there is a need for close to 70,000 social workers. This was said in 2005. And even in 2010, when the regulations were finalized before the parliament, these issues were being debated by parliamentarians, that we need so many social workers to implement the Children's Act. But now the question would have been, what do we then do? Because in terms of the number of social workers we have in the entire country, the figure that we had as in that is at the end of last year was about 34,000 or if not 37,000 social workers in the entire country, with 2,000 of those on retirement, meaning that the number of social workers we have as a country in South Africa alone is not sufficient to deal with this particular bill, or to deal not with this particular bill, but with the entire Children's Act. But now the department has been trying at all times, out of nothing, to ensure that at least something is happening. There are processes, I think my bosses may respond to that, in place to deal with that, but it is more of a challenge in the country, not a challenge with social development. Maybe the question that we would be asking as to why kids out there are not interested in doing social work. There aren't enough social workers being produced by the universities in order to deal with our challenges as a country. Maybe we need to view it from that angle, because it's a stock that we
Sorry.
have.
Sorry, Chair.
Okay.
Sorry, Chair. Sorry for interjection. I would like, sorry for interjection. When we are talking of training, I don't think as KZN we can be part of saying we are having untrained don't have social workers. We've got social workers that needs to be employed. So I don't think it has got to do with the actual training of the social workers. We are having a problem to employ the social workers that are already available. That is why
Absolutely correct. I agree with you.
Okay, thank you, Honorable Chair. And thanks for the clarification. I was just trying to paint a picture of why we are where we are and what are we busy doing with regard to that. I am mindful of the fact that there are social workers that are still not employed, but the supervisors may be present here will be able to speak about the human resource issues and why not social workers are not being employed. But I was just trying to indicate in terms of the study that was conducted in order to deal with the implementation of this particular piece of legislation. Thank you for that clarity. So it's one of the issues that we need to look at broadly. And this is not the only piece of legislation that requires social workers. We still have even other departments that are also looking at the need for social workers. The Department of Health, the Department of Correctional Services, the Department of Justice, and all that. Again, Honorable Chair, the issue of the clauses, what was the mischief that needed to be cured, and how that mischief got to be cured. There is a memorandum on the objects of the bill. There is an MOO that is supposed to be attached or that should be part of the bill. I think it is part of the bill that was shared with the portfolio, with the NCOP, which explains why each clause had to be thought of and developed. So if it is not sufficient, then we can still go deeper into that and try and explain each clause. For example, in my presentation, I did make mention of the fact that when you look at clause 2 or clause 3, you'll find that it is about guardianship. The amendment of section 24, the amendment of section 45 as a consequence, and those amendments, they relate to the issues of guardianship, where the guardianship is being, the mandate or the jurisdiction of the Children's Act, Children's Courts, is being extended in order to deal with issues of guardianship, where we say the more access people have to guardianship, the lesser children will be in need of care and protection. And in that way, those children will be having guardians through the applications made via the Children's Court, which is less expensive and not time consuming, as is currently the case today with the High Court. So that is the mischief that is being cured with regard to clauses 2 and 3. That is amendment of section 24 and also the amendment of section 45. That was the explanation. And I also made an indication that with regard to clause, say, the number of clauses, I said 12 clauses that were extracted from the bigger bill. And one of those clauses I did not make mention of is just the definitions clause, which makes it 13 clauses. And then there is a clause that got to be a consequence of amendment, which is clause 45, because it had to be read with section 24, the reading of section 24 with section 45. And then section 45 made as per the advice of the members of parliament that made it into the list. And then there was a need to amend section 150, but the look at the end, at the wording of section 150 necessitated a consequential amendment, which is section 160C, capital A, in the bill that is before your good selves, honorable members, which then made these clauses 15 altogether, excluding the short title, which is the 16th clause. So the 12 clauses were actually 13 if we would include the first clause, which is definition, but it was not an issue because it's just a definitions clause that is not substantive, making them 13 and 2 of them being consequential amendments and the 16th one being a short title. So that is how the provision the bill is structured. Again, with regards to the issue of what each clause entails, the presentation looked at the entire bill in terms of what these clauses entail under general, because at the end of the day, what these clauses need to achieve is a comprehensive legal solution as indicated by the High Court, that is the North Gauteng High Court. It was in 2017 and today is in 2022, and one of the issues that challenged the development of this, you will notice in terms of the notice of introduction to Parliament to introduce this bill, it was done within a reasonable period, or the period within which the North Gauteng High Court indicated. So the minister had complied in that she was given 15 months within which to introduce this legislation in Parliament. And sometime in February 2019, she did exactly that. But we had a challenge of general elections at the time, and there was a change of administration. The bill was kicked out of the system by Parliament. It did not survive as those bills that would not be started afresh after the new administration. And when it was started afresh during the new administration, COVID hit the country. Parliament, I'm just answering on behalf of Parliament now, because on the side of the department had finalized the bill. The bill was already before Parliament. But now, Parliament could not go around the country due to COVID restrictions, as public hearings require that people must be assembled in a particular place. So all those put together caused the challenge in terms of why it has taken so long to be where we are now. It has not taken long on the side of the department, as the department finished and finalized the bill on time and the minister introduced it in Parliament. With regard to the issue of, back to the issue of the mischief that had to be cured around this issue, the metrics, if it is required, it can be shared with the legislature. The matrix is there as to what people had said about these clauses and what the department had responded. So it is a matrix that was before Parliament, which we shared with Parliament. We were hoping that the package from Parliament also included that matrix in bringing the documentation before the Honourable House. Again, the issue of the tools of trade. Yes, I think my colleagues will respond to that. And basically the issue that is contentious. I was indicating that these are the issues that there are so many contentious issues in the entire bill. That is 146 clauses that we presented in 2019 before Parliament. There are so many contentious issues, but the one that relates to this particular bill is the one around clause 10, which is section 21. That is what I referred to in terms of, not that there may not be others that may be picked up during public hearings that the legislature is going to hold, but at least this one is the one that has come up sharply from time to time. And as I indicated, it is a contentious issue because of misconception of the thinking of the department, because the department itself recognized the issue of parity that needs to be looked at between married fathers and unmarried fathers. But unfortunately, because of South Africa being a multicultural, multi-traditional, and cosmopolitan country, many issues came around this particular issue to say, yes, for the other traditions, it may be fine. You can impregnate a child as an unmarried man. You can impregnate someone's daughter, and you can walk in and out of house and have custody of that child and all that. But the traditional leaders in our community said no. With regard to the traditional communities of South Africa, that is not acceptable. You must first pay damages before you can have that kind of access. So I'm trying to say these are the issues that were raised by the traditional leaders, which then made this to be a contentious issue. And again, with regard to that particular one, the commentary that we received around this particular one had challenges because it expanded the whole notion of the rationale for that particular provision. So it may not necessarily be the only one when you go out, but this is the one that is upfront that we need to be mindful of. Thank you. I think I must give over through you, Chair, to my colleagues to respond to other parts. Thank you.
Okay, thank you, Chairperson. Good morning, honorable members. My name is Isabella Sekawana. I must apologize because I thought I joined the right meeting. I was in another meeting because we are having the parallel session. So that is why I joined up late. I want to apologize for that. I'm working in the Department of Social Development under Welfare Services program. Chairperson, I must start by appreciating all the comments that have been made by members and the questions which are really wise and are assisting us in terms of applying our minds on certain issues. Some of them are not to be responded to, but just to really take them and improve on what we have presented or what we have done. I want to talk, Chairperson, and agree with honorable members that even though we can come up with a beautiful legislation, we still require resources, we require skills, and we require capacity to deliver on those resources. And I want to take this bill as one of the bill that is taking into consideration the crisis that we are having as the department in terms of the manpower, the social workers that we are supposed to have, for them to be able to deliver. Given the fact that we are confronted with social ills, we've got, high scourge of gender-based violence. We've got substance abuse that is on the rise, and we are having all sorts of social ills that are really increasing on a daily basis. That requires us to ensure that we employ more social workers. And as a result of the fiscus in the country, we are finding it very difficult to get the numbers of social workers that we require to deliver. And I want to agree with members that as the Department of Social Development, at some stage we were confronted with, exodus of social workers who were leaving the country and going to other countries, seeking for greener pastures. And we had to come up with an initiative of the scholarship program where we had to recruit young people, and other people who want to do social workers so that we can be able, to have social workers who will deal with the issues of the country. However, as we start started, we were able to absorb the social workers, but as time goes on, we were confronted with an issue of not being able to absorb social workers as a result of resources that we are faced with. As I'm talking now, I think we've got more than 9,000 social workers that we trained, and we have not been able, to absorb. Now, going back to what advocate has said, as the department, we sat down, we tried to look at this issue, and we realized that we are not the only government departments that is really using social workers. We've got other government departments that are very critical. We've got, education. We know that quite a number of child protection issues that are emerging, your teenage pregnancy. We've got bullying in school. We've got quite a lot of issues that are arising in education. But we also have SAPs. We've got correctional services. And then we were instructed by Cabinet. We went to Cabinet, and Cabinet instructed us, to ensure that all departments, employ social workers. We, as the Department of Social Development, we led the development of a strategy for employment of social workers in the country, where we engage all the relevant government departments, and we all agreed that we need to do a bit together, which we did as a department jointly with other government departments, and it has been presented to National Treasury, and our minister has been engaging with the Minister of National Treasury in this regard. We hope that we'll be able, to succeed, so that we can be able to employ more social workers to implement both this bill, but other pieces of legislation. We've got legislations that are specific to programs, substance abuse, you name quite a number of them, and we hope that we are going to win, because we can see that, in every platform, I think this issue is gaining momentum. So we believe that as we pass this legislation, we will be able to implement it. But secondly, I must say that this legislation, the bill that we are talking about, is also going to assist us in terms of seeing how best can we really ensure that we alleviate a burden from social workers, because as we are talking now, each and every orphan has got to go through foster care process, and you can imagine how many orphans we are having in the country that have got to go, and we are denying these children a right to support, because for them to be able to get financial support, most of them will want to go through the foster care process. Of course, there is child support grant, but because of maybe the fact that it is little, or as compared to foster care, it's little, people prefer to go through foster care. Now, having said that, the foster care grant has been topped up at 50% to ensure that it also caters for these children who require financial support, and not necessarily, as advocate has said, in need of care, because we know that our families in South Africa are diverse. There are those that are headed by grannies, there are those that are headed by single parents, but there are those that also stay with the relatives, because of people migrate to look for employment. And as such, as an orphan, it does not necessarily mean that all orphans are in need of care, but they are just in need of financial support. And this makes their lives very difficult, because when a child is getting child support grant and she get orphaned, it means that she has to go and apply for a top-up grant, which is at 50% of child support grant, which will enable that child to gain the financial support. And this child is not supposed to be subjected to foster care processes, and that in itself, it says it reduces the burden on the foster care system, because only children that require foster care processes, that are in need of care, are going to go through the foster care, and those children that are in need of care, also the turnaround time in terms of them being attended to is going to improve. So this legislation, and I want to agree with members that we really need to simplify the benefits of this bill, so that it can be understood by the people on the ground who are supposed to benefit from this, and we need to really do it at a layman's language, so that the people understand. Now, the issue of NPOs, yes, it's an issue that has been deliberated, and we're still engaging about the disparities in salaries of NPOs versus those social workers that are in government. It's a big issue that we continue to engage on, and we will continue to do so. And we are quite aware that, the social workers are not getting the same salaries as those that are in government. However, having said that, in our discussions, we realize that we should also not compromise the independence of the NPOs, because they are the ones who determines the salaries, of the employees in their employment. But at the same time, we are mindful of the fact that, maybe the subsidies that are being provided are not quite adequate, to can ensure them, to give the social workers the salaries, the same salaries as those of government. So this is an issue that will need, continuous engagement, but at the same time, it will also need, the fiscals, the resources, to be available, so that, maybe this issue can be dealt with. I'm not sure as to whether there is an issue that I have not spoken about. If there's an issue, I will be advised by members, but I can also leave it to my colleague, Niliswa, maybe to deal with those that I have not dealt with. Thank you very much, Chairperson.
Thank you so much. Thank you so much for the responses. And thank you so much for this question. It shows that you have applied your mind to the question. Is there any follow-up, honorable members, so that we move to the next item? Daphne, I thought your hand was up.
Yes, thank you, Chair. I have a follow-up on the question that I had asked earlier regarding the contentious issues that were raised by the colleague regarding clause 10. Chair, when I look at the B18B 2020 bill that we have, this clause merely inserts section 159.2, clause 2 capital A and clause 2 capital B, and those clauses talk about the extension of alternate care orders by the courts, basically. And when I looked at that slide, unfortunately we didn't get a copy of this presentation beforehand. I don't have it with me, but I recall you was talking of issues around the rights of single parents, the issues that were raised by traditional leaders regarding things like payment of damages and all sorts. So I'm not sure how does that talk to clause 10, as he's citing clause 10. And like honorable members were mentioning, that it could have helped if this presentation was done clause by clause, then we'll understand what the issues are per clause. And, now having a holistic and a general presentation, it's not really talking to what we'll be presenting during our public hearings, as they are articulated in the explanatory memorandum of the bill. So I'm not sure how we're going to deal with this. Maybe I might have to redo a presentation that talks to clauses as per, the memorandum on the objects of the bill. Then we'll be able to when we do our public consultations, go through the bill clause by clause and what the real issues are being raised per clause. Because at the end of the day, when we vote on this bill, we'll be voting on it per clause. I'm not sure if my question is understood. And lastly, Chair, I'm just curious on whether this bill as it stands, is it merely looking at complying with the court order? Or I understand that the initial bill had over 140 clauses that were covering the child protection area holistically. But I wouldn't want us to be found to just being in compliance with the court order, but more issues are going to be raised due to, the current bill being lacking on certain aspects. If maybe I could get clarity on that as well. Thanks, Chair.
Thank you, Daphne. Over to you, Leander? Thank you so
thank-
much.
Okay, thank you, Honorable Chair, and thank you for the questions. Uh, I think I must agree that I may have failed to explain the context around Clause 10. It's not Clause 10 of this bill. It's Clause 10 of the entire bill of 146 clauses. That is why there is no link between what I was saying and Clause 10 of this bill with 16 clauses that is before yourselves. What I was just indicating was that the bill initially had 146 clauses, and some of these clauses were removed from that bill because of the migration of ECD to DBE. And then we remained with a bigger bill as well, around about 130 or 40 or so. And further than that, there was another need for the removal of the clauses that speak to foster care. That is in response to the North Gauteng High Court order. These are the 12 clauses that ended up being 16 with the explanation that I gave. The clause 10 that I was referring to is the amendment of section 21. It's not part of the bill before you altogether. But because when you go for public hearings, people out there, they take you outside the bill. They are still complaining about that clause, that amendment to section 21, because they wanted that section 21, which is clause 10 in that bill. That is the bigger bill that was introduced to Parliament to be part of these 12 clauses that we are discussing today. So it is not clause 10 of this bill altogether. It's clause 10 of the bill as introduced in Parliament in 2018 by the minister. I'm not sure if I've covered that. So it is something that people raise from time to time when we go around. Why did you not include clause 10 in this bill? So that is the response I was giving, that it's a contentious issue that people wanted not only these 12 clauses to be part of the foster care clauses responding to comprehensive legal solution, they wanted more of those. And clause 10, that is amendment of section 21 of the Principal Act, being one of those. So it's not linked. So the clause 10 is not linked to the clause that my honorable colleague was referring to in this regard. Thank you.
Thank you. I think it's clear, Daphne.
Yes. Yes, Chairperson, if I may come in, I think the second question that Daphne asked was about, are we chasing the deadline, and are we really making justice to the process? I think Luyanda has mentioned that when the consultations were initially made by us and the portfolio committee, it was looking at the entire bill, and the inputs were received and were consolidated. And because we have, yes, definitely to adhere to the court order, if failure to adhere to the court order, it will mean that all the orders will lapse. And what will happen to our children? They might not, receive, the foster care grant. And I think that is why this was prioritized, to say that let's prioritize the clauses on the foster care. And I think Advocate has mentioned that there is a committee bill that will take into consideration all the issues that have been raised, including the clause 10 that Luyanda has spoken about. It does not necessarily mean that what people are saying is not to be considered, but it will be considered later in the committee bill. Now, having said that, we believe that once this bill has passed, For us, it will benefit the children of South Africa because, firstly, number one, as I said, those who qualify for foster care will not wait much time as they used to because we will have ensured that the system is efficient. Those children who are not supposed to be part of the foster care system will have been removed, will be catered for with the top-up grant that we have spoken about. So it means that those children will benefit. Those who are in a system also will also benefit because their court orders will not take long, to be extended. But thirdly, even the children themselves that are orphaned are not going to be subjected, as I said, through their foster care process for them to be able to gain financial assistance. Because we know that, we know even in the olden days when we grow up, some of us were taken care of the families. We have seen orphans, people, the orphans who have been taken care by family members. And during that time, there was no financial assistance, but we know that they need financial assistance. All what we need to do is to ensure that these children are well catered for. But having said that, those that are in need of care, not all orphans will be regarded as not being in need of care. There will be those that are in need of care who will have to go through the system. Thank you very much.
Thank you so much, and thank you for the responses. We are now clear. I think it is clear now. The advocate was actually trying to give us an idea that what will happen when we do these public hearings, especially around the amendment of Section 21 of the Principal Act, Clause 10. It's not necessary that all these things are included in Clause 10, but the people will raise it. The issues, the rights of unmarried fathers, the limitation of rights, issues of custody, issues of payment of damages, issues of single parents, issues of guardianship, and so forth. So it is clear now. I understand. May I request that the department, through you, I think, advocate, can you share the same presentation that you have tabled to us today to the legislature? We can appreciate to have this presentation because we did not receive this actual presentation. The only presentation that we got is the presentation that you did at the Select Committee on Monday. That one also it also included clauses. It shows there was a breaking down of clauses. It went clause by clause. It was clear. So I hope that a legal advisor will keep that presentation, and also if you can get this presentation, because I suggest that before we go to the public hearings, can we have, as the committee, can we have a briefing of the committee of the legislature whereby the legal advisor is going to take us through the bill again, so that when we go to the public hearings, we know exactly, as Honorable Madonna was saying, to say if you can make it simple so that it is also simple to us, and as we go to public hearings, it is also simple for the people out there in a layman's language. So that's what we ask a legal advisor. If there are things that you need to understand, please contact Advocate Luyanda Matontisa. I think he can brief you aside before the date, and I would suggest that maybe we use the date of the 29th, because on the 29th we will be having a meeting of the Portfolio Committee of Social Development, whereby we'll be discussing about the first quarter report, and then afterwards you can just take us through the bill. Members, can we go to the way forward in terms of public involvement? What are you suggesting, honourable members? According to me, I was suggesting that this bill, it affects the whole province because it talks about children. I'm of the view that we need to touch as many areas as possible. That is my suggestion. If you allow me, I'll just give you the suggestion that I'm coming with as the chairperson. I suggest that we have two teams. There's the team A and team B, provided the department is going to give us two people who will also be part of the public hearings. If they can tell us. I suggest that team A goes to Umkhanya Ude, Amajuba, Ugu, Umkungunju. Yeah. Umkhanya Ude, Amajuba, Ugu, and then Umkungunju. And then it will be led by Honorable Swartboy. And then team B will be led by Honorable Majola. It will go to Zululand, Umzinyati, Herikwala, and Etegwini. That is my suggestion, honorable members. But the dates, I will suggest that Noctula Shemu just come up with the date. Having in mind that we need to submit our negotiating mandate by the 25th of October, 2022. So the first mandate is submitted on the 25th of October 2022, and the final mandate will be on the 8th of November 2022. What do you suggest, honorable member? And also, I want the department to commit themselves that they are going to be part of these public hearings because you are the drafters of this bill. I can see Honorable Tembe. I don't know whether it's you. Oh, it's Stephen. Oh, okay. Let's Governor. Honorable Les.
Yes, thank you very much, Chair. Yeah, Chair, no, I like your suggestion of two teams so that we get into the various areas around the province. And I would like to suggest that we must get that briefing on the 29th so that when we go out, we are clear in terms of why we are going out there, and we will be able to respond to any questions and comments that might come from the people of our province. So, I am very happy with this with the suggestion that you've come up with, Chair. I will second that.
Thank you. Honorable Tembe.
No, Chair, I just wanted to also agree with your suggestion, Chair. I think it's the best suggestion to go as far as wide as we possibly can. Thank you, Chair.
Honorable Majola, I don't know whether your hand is up, and then I will take a Daphne and then Margaret. Honorable Majola.
No, Chair, my hand is not up.
Okay. Daphne?
Thank you, Chair. Chair, I do agree with the splitting of teams to cover all the districts. However, Chair, I just wanted to raise the issue that there's only one legal advisor for the committee, and possibly we can work with the guys with IT that I can be in a central venue and be able to deliver the presentation to both, to the venue. So we have to ensure that when we sit at Umkhanya Gude, we should sit at the same time with Zululand and so forth. and then I can be able to deliver to both venues at the same time. But it can be done, Chair. I think it's logistics that we would need to work on. And I will have the presentation ready before the 29th for the presentation, for the briefing of the committee on the 29th, Chair. Thanks.
Thank you, Daphne. I think legal advisor, those logistics, we are going to deal with them aside out of the committee, because that's why I want the department to also commit themselves, if it's possible. Even if maybe we get one, because we can use you in one of the teams. Are they available to the public, to assist us in the public hearings?
Yes, Honorable Chair, if I may just jump in like that. I can say tentatively we are available because the challenge is that we don't have dates for all the provincial legislatures. Maybe until such time that we know which province is conducting public hearings when, then we'll be able to be very definite that yes, but we will avail ourselves in one way or another. Thank you.
Okay, thank you, Advocate Michael. Margaret?
Thank you, Chair. Chair, just to let you know that the Select Committee has extended the dates of the mandates. So now the negotiating mandate is scheduled for the 1st of November and the final mandate for the 8th of November. So it does give your committee a little more time to have your public hearings in all the areas that you've indicated. Thank you.
So the final mandate, when will be the final mandate, Margaret?
The final mandate is the 8th of November, and then the negotiating mandate is the 1st of November.
Okay. Thank you so much, and thank you for the presentation, and thank you for having this bill being presented to us. I think we need this bill. As you are saying, so the department, as Isabel is saying, that it is a very important bill, because especially for the foster care, for the beneficiaries of foster care grant, this bill it needs to be speeded up, because it will avoid the delays for them when they apply to be the foster care people, and not to be taken via the court, waiting for the court, and it causes a lot of delays. So this bill, it needs to be speeded up. And thank you for the presentations, Advocate. It shows that you know your story. We thank you so much, and we thank you also. I want to also extend my thanks to other officials of the department who have also participated and responded in the questions. You have empowered us. Can you please share the presentation that you have just tabled before us, and also share the metrics with the legislature, the one that I asked Advocate Luyanda? I'll be happy. Thank you so much, and thank you, honorable members, to come to the meeting, and also I want to thank the support staff for organizing this meeting. This meeting is adjourned.